Sakina Orembo breaks down the details in our feature of the week.
The ruling was delivered on 30th June 2025 after the court dismissed a case filed by Fatuma Faraj, a widow to Salim Juma Kitendo. Faraj, who had 4 children with Kitendo in a formal Islamic marriage, asked the court to block other 2 children, Ruth and Marlin, from receiving any part of the estate, arguing that they were born out of wedlock and are not entitled to receiving any inheritance under Islamic law. The Supreme Court upheld earlier decisions by the High Court and the Court of Appeal, stating that denying children inheritance based solely on their birth status was unfair and went against the Constitution. The court referred to Article 53, Section 2, which says that child's best interests are of paramount importance to any decision involving them. Denying children inheritance simply because they were born out of wedlock is unjustifiable and unreasonable, the judges stated. The court also addressed Article 24, Section 4 of the Constitution, which allows religious personal laws like Islamic law to limit certain rights, but emphasized that such limits must be reasonable, justifiable, and clearly defined. The judges concluded that completely excluding children because their parents were not married was too broad and unconstitutional. They referred the matter back to the High Court in Mombasa for a distribution of the estate, ensuring that all the biological children of the late Kitendo are included. However, the Supreme Council of Kenya Muslims, National Muslim Leadership Forum, and the Council of Imam and Preachers issued a statement against the ruling, saying it undermines the Constitution, which recognizes the application of Muslim personal law in matters of marriage, divorce, and inheritance. SUPKEM warned that the judgment sets a dangerous precedent, erodes the sanctity of the marriage according to Islamic faith, and will lead to widespread legal conflicts and confusion within the Muslim community. The leaders expressed frustration over a similar 2019 ruling in which the Apex Court overturned the Court of Appeal decision that had upheld the right of Muslim schoolgirls to wear the hijab. The Muslim leaders appealed to President William Ruto, calling on him to defend constitutional rights of Muslims and safeguard religious freedom. They urged the Attorney General to seek an advisory opinion from the Supreme Court to protect religious and cultural minorities from judicial overreach. They also called on Parliament, particularly Muslim representatives and members of the Justice and Legal Affairs Committee, to introduce legislative protections for Muslim personal law. Addressing the Muslim community in Kenya, SUPKEM appealed to the Qadi courts to issue clear guidance on protecting family rights and managing estate distribution in accordance with Islamic teachings. They called on Muslims to remain informed, united, and proactive in defending their faith and religious rights within the law, emphasizing that Muslims have never imposed their religious rulings on others, but will not accept the imposition of rulings that contradict their values and sacred principles. Other legal experts welcomed the decision, saying it closes a legal gap that left many children vulnerable regardless of their religious or customary beliefs. Under Islamic law, children born outside of marriage are only legally connected to their mother and maternal lineage and are excluded from inheriting from their biological father because Islamic inheritance rules are based on lineage through a valid marriage. While they are not denied care or support, they are typically not included in the standard of succession. Sakina Orembo, Alhuda TV.